Oh,
I will let you know once it says that it's ready. Mhm.
I think
Okay.
that's it. All right, we're live.
Yes.
Fantastic. So, hello everyone. Welcome to the Maryland Family Law House Judiciary Committee Subcommittee. So, today my name is Delegate Karen Simpson, and I am the chair of the Family Law Subcommittee. We have our members here, and we're going to discuss two bills, but we're going to start off with our marriage bill. So on the eve of Valentine's Day, Delegate Simmons brought to us our love bill. So I'm going to turn it over to Delegate Simmons to really briefly explain what this bill does. And he does have a sponsor amendment.
Thank you, Madam Chair, and appreciate you bringing this bill. This is House Bill 95. We just heard it in Judiciary, presented with marriage license applications. This bill centers around with our state clerk's office is their way of correcting what they see to be is a problem with the current process. It allows for individuals to make sure that they are present when requesting a license. Right now, the current law does not allow for both individuals to be required to be present when applying, being issued a marriage license. So this would correct that and allow them to be both present, or in certain circumstances, the clerk may waive that due to an affidavit presented based on reasonable cause to issue it without the second individual being present. I have with me Anne Arundel County Clerk Scott Foyer that's on as well to talk about the amendment as offered.
Thank you very much. And we do appreciate this marriage by consent bill. So do we have Scott on? Do we have the Honorable Scott Foyer, the clerk?
Yes, he's on. Go ahead, Scott.
Thank you, Delegate Simmons, and thank you, Chair Simpson. Yes, we greatly appreciate you considering this bill. This would be one more tool in the toolbox to help the clerks fight marriage fraud in the state of Maryland and also human trafficking. There was one set of comments that we took care of before it was after the bill was submitted, but before the hearing, we got these amendments, and the amendments came in based on comments we received from the Bar Association that they wanted us to beef up the waiver process for folks who legitimately can't both appear in the clerk's office. And that's why those amendments are in there. They're really looking to strengthen the waiver. If somebody's incarcerated, if somebody's in the hospital, or if somebody's just for other good cause, or somebody's in the military, other good cause, if somebody really can't make it in, it leaves it to the clerk to be able to ask the questions and be able to accept an affidavit in lieu of them coming into the office. Can I answer any questions on the amendments or the underlying bill?
Okay, so do we have any questions from the floor? Anybody have any questions? For our sponsor or
See, Vice Chair Davis is.
yes. Vice Davis Chair Davis, would you like to ask a question?
Yes. So this bill would still require one person to show?
It would, you could have both people provide an affidavit. The normal expectations that there would be two people that would show up. And then you could have one person with an affidavit or both could provide an affidavit. But very, very, very limited circumstances would we accept something like that. I would normally they would both have to one would have to show up with an affidavit.
So what's the purpose of changing it so that so that both people could arrive could not be there in person?
Well,
Doesn't that make it more prone to fraud?
no, the expectation is, well, right now, under the current circumstances, one can show up and we never see the other person.
Got it.
What we're trying to do with this is have both people show up, which is what we're expecting is the normal set of circumstances. And if there's a special set of circumstances where either one or both can't show up, and I'm trying to think of a situation where both couldn't show up. If they, for instance, if they were both out of the
Marriage
country.
residents, Maryland residents, and they're both in the military, would that be
Exact,
one? But they
exactly.
want to be married in Maryland.
Yes, they were deployed overseas or maybe just in another far-flung state in the United States, but they wanted to be married in Maryland. We would ask them to justify that. The clerks would say, this bill would give us the opportunity to ask the question, make them provide additional information. And if we did feel that it was legitimate, then we could issue it. The marriage license, issue the marriage license.
Thank you.
Oh, thank you, Vice Chair.
Any other questions? All right, are we ready to vote on this bill as amended? Looks like we do have our quorum. Would we like to, so in short, this bill is going to require two people to be there in order for a marriage license, except under these, and the bill sponsors amendment has it so that they're under certain circumstances in which with an affidavit that only one person, or of course they could do the affidavit. So
Madam Chair, I see Chair Williams is raising her hand.
I did initially. Sorry about that. I was trying to raise my hand, but you sort of answered it about, I was wondering what was in the amendment, but it's the exceptions under which someone can do an affidavit so that just one person can appear. So I think I'm okay now. Thank you.
yep, everyone should have a copy of we sent a copy of the reprint as well as the actual amendment. Lauren, just make sure that we're checking with council. Did we
Yes.
cover everything? I believe so. It's incarceration, hospitalization, other good cause, military service.
Yes, and just just a point of procedure, you're gonna want to adopt the amendment first separately and usually by show of hands, and then you take a vote and do a roll call for the vote.
Okay. So with a show of hands, do we adopt the amendment? I don't see any hands, so.
Oh, hold
Okay,
on.
there we go. We got hands. Hands are going up. Okay, looks like the amendment has been adopted, and now do we, let's have a roll call for the, do we adopt and pass favorable the bill as amended? And I'm gonna let's see, I do have the
Do you need a
list.
motion, Madam Chair? I move that we adopt the bill as
Yes,
amended
you-
favorable.
Second. Moved and seconded.
Okay, so let's take the roll call on our bill as amended. So Delegate Boucher,
Yes.
Delegate Davis, Vice Chair,
Yes.
Delegate Mangione, I know he was on.
He's on. I think he may be trying to unmute.
Okay. I see him.
We may be able to move on and come back to him.
Okay, so Delegate Marino, I didn't see him on here actually.
Delegate Moreno, yes.
Okay, Delegate Simmons,
Yes.
Delegate Stinnett,
Yes.
Delegate Williams,
Yes.
And the chair votes yes.
Delegate Taylor votes aye.
Are you on the family law? I didn't see you on the. Okay. All right. So this passes and we will send it to the full committee. Thank you very
you.
much. And now we will move on to our a discussion on our second bill. Thank you very much, Delegate Simmons, for giving us our love our bill for the day so that we can celebrate Valentine's Day together.
That's it. Go get your marriage license.
Go get your marriage license if you don't already have one. All right, so we're going to move on to and bring in our guests for our House Bill 48, which is our Senate our terminating parental rights bill. This is Delegate Tolls's bill. We should have her on. We don't actually have an amendment, but there was, we just want to have a discussion about this bill because there was a recommended amendment, but we don't actually have an official amendment. So we're just going to have a discussion. Is Delegate Tolles on?
She may still be in our delegation meeting.
She's on. She's
I'm
reflecting.
here.
She probably need to unmute Delegate Tolles.
Okay. Delegate Tolles, you want to briefly explain to us what this bill does? It's a Senate and a terminating parental rights bill.
One second, delegates.
But yeah, thank you. We've just voted on that one. Yeah, thank you. Mhm. Okay.
I'm sorry about that. I had to just let them know that I was in. Thank you. Can you hear me, Delegate Simpson?
We can hear you.
Can
Thank
you all
you.
hear me? Okay.
Yes,
So
we
you would
can.
like for me
Yeah.
to
Just quickly explain what the
Okay.
bill does.
Sure. Thank you, Madam Chair. Essentially, what the bill does, it would allow, as I indicated in subcommittee, I'm sorry, in the full committee, it would allow for parents who have had their children taken away, the ability to not have subsequent children be taken away for whatever reason. And I had this bill last year, so just bringing it back. And it's on behalf of the Office of the Public Defender. So I just wanted, to hopefully get a favorable report. Thank you so much, Madam Chair.
Okay, and to be clear, the bill does not take out, it only takes out if they have previously lost custody of their children involuntarily because they challenged it. Otherwise, in the bill, still under termination of parental rights, still has in all of the issues, the normal issues, which is if they had the sexual abuse, the chronic, if they've actually killed a child, all of those things are still in there. Automatically, they would lose custody of another child. This is strictly the difference in these two. The issue is someone who did not fight the termination of parental rights versus someone who did. That's the involuntary part. Is that correct? And if you need me to defer, we do have Justin and I do believe a representative from the department on. That really is the crux of the question.
The gist of it, yeah.
Whether or not that it was involuntarily or voluntarily terminated, being able to, whether it automatically severs the parental rights, correct?
Correct.
Okay.
Thank you, Madam Chair.
Did you want to call on Justin or someone from the department for any further clarification?
So we have someone, is it possible for someone from the Office of Public Defender to come on? That is the agency within the,
I don't
I'm
think,
not sure who is here from the Office of Public Defender.
I
Natasha?
don't believe they're on.
Yeah, I don't think that they are on.
Yeah, somebody should be on. Let me. I
We
don't
do have
see.
the department, and the department is,
Okay, that's
in
fine.
they do support the bill.
That's
So
fine.
if they want to share,
It's okay. Yeah. Thank you.
Morning. My name is Heather Zanoni, and I'm serving as the Assistant Secretary for Policy and Data at the Department of Human Services. And I'm happy to say that HB 48 is the right thing to do. Terminating parental rights is frequently referred to as the civil death penalty. And in most cases, child welfare agencies work to reunify children in foster care with their parents. Efforts to reunify families are critical for preventing the trauma of unnecessarily terminating parental rights. Great care should be taken prior to terminating parental rights unless there are extraordinary circumstances. And courts should have the discretion to assess parental capability in child in need of assistance cases rather than requiring courts to consider a prior contested termination of parental rights. Every family situation is different, and in most situations, families deserve careful consideration of their present circumstances and capacities before the law permanently and irrevocably severs them from each other. DHS supports the changes proposed by HB 48 that prioritize critical developmental connections between children and their families because family matters. Thank you very much for your bill.
yes. And do we have any questions from our committee members? I'm going to call on Delegate Boucher for his comments or questions.
Thank you, Chairwoman. I'm curious as to how far the bill went last year, and are these modifications going to solve whatever held it up to get it through?
I'm not sure why it didn't move last year, but it's pretty much the same way that it was, Delegate Boucher.
All right, thank you. Let's hope for the best.
Thank you.
Did it have a
Yes.
higher number?
I'm sorry?
Did it have a higher number? I mean, it's 48. That's pretty low.
Yes,
What
yeah, maybe, because I pre-filed it from the same way as before.
Okay.
Mhm.
Ma'am, you were on mute.
Any other discussion that any other committee members have any questions about this bill and what it does? Okay, I don't see any. Does anybody else see anybody else who has, at this point, we're talking about the committee members. They do have the testimony. And as I've said, we will take that under consideration at this point.
Madam Chair, Ms. Phillips is raising her hand.
May I speak, ma'am? Is it okay?
Delegate Simmons, do you have a question of Diana, of the Coalition to Protect Children?
No. She was raising her. I was just making you aware that she was raising her hand in the chat.
Madam Chair.
What?
Yes, Delegate.
No work. Go ahead. I'll follow your lead. Go ahead.
Well, Madam Chair.
Mm-hmm.
Actually, I'll ask a question of Ms. Phillips. Ms. Phillips, do you have any additional comments that you would like to make with regards to this legislation and the perspective of the coalition?
Yes, thank you very much. With the Coalition to Protect Maryland's Children, which includes Maryland Legal Aid, that had offered testimony in favor with an amendment. So the concern is about the involuntary loss of parental rights. This is what we've been hearing about TPRs. And so what we're thinking is that there needs to be a balance. There's a tool that can be used for child safety when there's a subsequent sibling in which the local department is asking for a waiver of reunification efforts. So the way that the law is right now is that when a waiver is submitted by the department, the court needs to rule. And if there's specific circumstances, which right now, all the circumstances in the law, it says that the judge shall rule. And what we're proposing is that for all those aggravated reasons, the judge can continue to shall rule in favor of the waiver being granted. But what we're proposing is for a circumstance in which there's an involuntary
I vote
parental
aye, and
loss.
explaining my vote, I think that this is going to be a good thing for our
Delegate
district.
Taylor, not
We have
Someone
several
mute Delegate
department heads
Taylor.
that want to host wine festivals that have been trying to do this, and I think it's important to repeal the restriction that was only set for District 24. Thank you. Thank you. Delegate,
I don't know who the host is.
Delegate Boafo.
It is Jocelyn. Jocelyn has control, so she should be able to mute or.
Delegate Fennell.
Jocelyn, I need you to mute Delegate Taylor.
Thank you so much.
Good.
Okay.
Okay. So what we're proposing is that if there's been an involuntary loss of parental rights, that the judge may grant the waiver. So there is discretion by the judge, taking consideration everything that Parents Council and Children's Council have to say, rather than an automatic.
I can always come back. Delegate Harrison. I vote aye.
Anyway, that's what we're proposing for the amendment, because we think it's a good balance between parental rights and child safety, so that tools still can be used when they believe it's not the best interest of the subsequent child to be subject to reunification efforts by the local department. Sorry, I've never had this problem before.
No, it's okay.
No, I think, yeah, it's a time, a lot of delegations are going on at this time of day.
It's not you, it's us.
And getting right and getting used to the Zoom and, you know, the screen and everything else. So thank you very much. As I said, we were going to bring this in for discussion. Do we have any other questions of whether our bill sponsor or the department or other guests about what has about this bill, about House Bill 48. I do want to make sure that it's clear. I hope everybody has read the bill. Many of the things they're already there as far as when they are taking consideration that would result in an automatic determination of parental rights if there are certain circumstances. They are there. This bill does not change that. I don't see any other hands. Could be wrong. Oh, yes, I do. Delegate Nicole Williams.
Hi. Thank you, Madam Chair. Quick question. So we were just discussing this, but there's an amendment that we're still waiting on this bill. Is that where the posture we're at this moment?
We don't have a sponsor amendment, and we don't have an amendment from anyone else on the actual. We have a suggested amendment by the coalition. We do not actually have an amendment.
Got it.
Do you have any other question?
Oh, no, I'll put my hand down. Thank you.
Okay. So Delegate Tolles.
Thank you, Madam Chair. And I apologize for all the back and forth with the delegations. I definitely know, and I don't know why the Office of Public Defender is not on. And I thank the department for their support and their comments. This is pretty much, like I said, the same bill that we had last year. And we would not want to add any amendment to it at this time. So I'm not sure, Madam Chair, if that's something that still can be entertained with possibly moving it forward, but we are not, I know there was some requests. We have worked on this, as you indicated, it's an early number because we worked on it, basically, putting it back in, and some of the amendments that have come through has basically change the spirit of the bill. So therefore, we didn't want to do that. So I would recommend that we keep it the same, and not looking to do any amendments from others at this time. I just wanted to kind of make that clear. And I want to thank you for your, communication that you've had with me, and we've, talked on several occasions. So I want to thank you for your leadership, as well.
And Heather, just a few more, if you can help us understand, am I getting this correct? That the difference is, so I'm just going to take, for example, Karen, and we're both, Delegate Tolles and we both lost parental rights. Okay, so I'm going to use this example. So Delegate Tolles, she fights really hard for her child, and she wants to keep custody of her child. Then a subsequent child is removed, and now you're at your termination of parental rights stance. Me, on the other hand, I've got an addiction. I don't fight for it. I agree to allow my rights to be terminated. I have a subsequent child is removed, and I did not fight the first time. And now the way it is currently written, right? I could continue, you could not get a waiver simply for that reason, because I didn't involuntarily lose the rights to my child. So if Delegate Tolles did, so that's the difference between having this in here and not having it in. Is that correct?
The distinction is correct. I want to add one more small thing. It's before the TPR. It's the decision of whether or not reunification efforts should be provided. So currently, no. The bill would say yes when there's a contested former TPR. Yes, we have a discussion about whether or not to waive reunification efforts. But otherwise, absolutely, that's a distinction.
So if you continue on that distinction, I would be getting reunification, whereas Karen, because she had fought previously, circumstance could have been the same, but because she lost, she wouldn't get those reunification.
The reverse. She contested, therefore she can say she should be able to have reunification efforts. You didn't contest, therefore less discussion over whether or not you get reunification efforts.
Okay. And I believe Natasha.
Diana, I saw a head tilt. So if I misspoke, I welcome her insights.
So right now, the law says that the judge shall grant the waiver if the department asks for the waiver on that subsequent child, which I've been told is a rare occurrence for the department to do it, but they're doing it because they feel it's in the best interest of the child, and it might harm the subsequent child from reunification efforts. But my understanding is that the involuntary loss of parental rights, even if you fought for it or not, it's something that the parent doesn't want, and so that's what in essence is it a TPR. I did want to bring up that the bill drafting makes it confusing because they stopped at the section which actually needs to be amended in 812. So the legal aid attorneys were trying to ask for an amendment on something that you weren't seeing in the bill, but they were seeing in the statute. And that is, again, saying that, yes, the judge shall grant, if the circumstances are all the aggravated things above the involuntary loss of parental rights. But what they're saying is for that balance and allow judicial discretion, allow that if it's an involuntary previous loss of parental rights, that the judge may grant the waiver. And that's where we think the balance should be. So that's my understanding of all this. Thank you.
Right. And it's not in there because it's not amended in any way. It's not changed in this particular bill. And then I do believe the Delegate Tolles did want the public defender on Natasha, is that correct? To Kafani?
Yes.
Is she
I'm
on?
here.
Okay.
I'm here. Can you hear me?
Yes, if you would like to.
So thank you for allowing me to be on. To answer your question, Delegate Simpson, you are correct. The way the bill is written now, if you have two parents, one actually had a trial and lost the trial on their parental rights, the other parent consented to just allowing their rights to be terminated, that parent who consented will be able to have reasonable efforts to reunify with other children, whereas the parent who fought and lost will not. That's the parent that the department can ask for the reasonable efforts to be waived. So the way it is written now, the statute really, the only thing it's doing is punishing that parent who said, no, I don't want my rights to be terminated. I'm going to have a trial on it. If they lose, then they're being punished because now the department can go ahead and ask for their rights to be waived.
Delegate Forbes.
And the court doesn't have any discretion. It says that they shall waive their reasonable rights. And the opponents keep saying that it's something that's not used often, but that leverage is used. So that is something that is used to get parents to consent so that, you know, they don't have to experience that on the back end. So that is part of why that statute, that part of the statute needs to come out, because even if DSS doesn't use it on the back end, they use it as a threat on the front end to say, we can do this for this other child, you know, if you lose this hearing. And that's also something that as a parent's attorney, we have to advise our clients. If we know there's another child in care already, and that's part of it, 3 siblings can come in at one time, and then they'll file to terminate one's rights. If the parent loses, then they'll go ahead and file to terminate all the other children's rights. So it's not necessarily that a parent continues to commit wrongs for these subsequent children. She can just have several children in care at the same time. And once she loses that trial for the one child, it makes it easier for all the other children's cases to be resolved in a termination.
Thank you very much for the clarification. And I just want to make sure that the committee does know. So I want Heather to we're not taking out, we're not touching any part of the bill that'll, you know, we are still keeping children who've been physically abused, chronically or severely, or sexually abused or tortured. This does not touch that.
It doesn't touch that in any way. It only takes out the involuntary loss of their rights by trial.
Okay, and I want to call on Delegate Williams. Do you still have a question? Did we lose Delegate Williams? Because her hand is up.
That might have been prior. She's not on unless she is stepped away from her camera.
All right. Do we have any other questions of our guests? I appreciate everyone coming on and explaining this bill. I really do. Do we have any other questions about this bill? All right. Thank you, everyone. You've given us a lot of food food for thought on this pre-Valentine's Day. Thank you, Delegate Simmons. We appreciate your bill, and I'm sure we will revisit our House Bill 48 in the future. So we'll see you all on the floor. Yeah. And do we have to declare adjourn, right?
Thank you, Madam
I move we adjourn if you need a motion.
Oh, yeah.
Second.
All right.
Thank you. I love having all these, you know, other chairs on the call.